afternoon, the third of the points about the relevant statutory scheme. And this one is headed Serious Disadvantages and Complications would be introduced if impact is required to be taken into account. Three features perhaps under that heading to draw attention to. First, we submit that introducing financial impact into that discretion necessarily involves the prospect of compromising the effectiveness of the scheme. It does so by creating cases in which HMRC could properly conclude that A, there is no reasonable excuse, B, there is no basis for exercising the discretion on grounds that, for example, they could be satisfied about future compliance, but C, financial impact then operates to preclude cancellation. And of course, if you preclude cancellation, the risks which the scheme is specifically designed to deal with are back in play. In effect, the unsuitable person continues to receive gross. Put another way, an insolvent defaulting taxpayer might retain gross payment status in circumstances where a solvent taxpayer responsible for a minor default would lose it. And that was a point that was correctly made, we respectfully submit, by the upper tribunal at paragraph 65. It introduces, for that reason, therefore, an extraneous consideration, which is entirely inconsistent with the faithful promotion of the statutory purpose. Financial impact of cancellation has nothing whatever to do with whether the taxpayer can, despite the failure, nevertheless be forgiven and regarded as trustworthy, solvent and reliable, so that HMRC can still be confident that the aims of this scheme will be as effectively upheld. And extraneous is used in that sense and was correctly used, we respectfully submit, by the courts below in that sense. So the Court of Appeal specifically defined the extraneous concept in paragraph 60 in this way. They described it as being matters which do not relate directly or indirectly to requirements for registration for gross payment and to the objective of securing compliance with those requirements. Contrast that with matters which are irrelevant to any issue of future compliance, as the upper tribunal at paragraph 65 put it. So that's the first of the features and is perhaps the key one. Secondly, under serious potential consequences of introducing impact into the discretion, introducing that impact would involve extremely difficult judgments, particularly in the context of this statutory scheme, about weight and balancing and how impact was to be weighed against the prospects of future compliance and the seriousness of past default. And that's a sharp issue, bearing in mind the overriding concern of Parliament to ensure the collection of tax and the fact that it is an inherent feature of the regime that loss of gross payment status, it's a point that's already been mentioned this morning, is almost by definition in this industry disadvantageous. That feature was the Court of Appeal's second further consideration. You'll remember the structure of their judgment at paragraph 65, citing Mr. Justice Lewison as he then was in the Hilton case, the short point being that an obligation to consider impact would place an ongoing and potentially serious and extremely difficult exercise on HMRC to balance and to try and weigh all those things.
You'd say, I mean, they're really incommensurable to...
Jolly difficult to do. I mean, they're either incommensurable or there are such serious difficulties as to render it inherently entirely improbable that Parliament would have introduced that level of difficulty without itself, particularly given the degree of prescription in the regime already, without itself giving some indication or guidance as to how that balance, incommensurable or otherwise, is to be struck. I think the point that the upper tribunal in particular had specifically in mind was the slightly more banal point, it might be thought, about the significant increase in the workload of HMRC having to do all of that, having to try to weigh those matters. But there is a more fundamental point within that, as it it may be thought, which is how on earth do they go about doing that? And the third linked difficulty...
Whereas there isn't that difficulty in relation to penalties, because you're just deciding whether to relieve someone of a financial sum.
Exactly
measuring
so.
hardship against hardship.
Hardship against hardship, and it's across a range. Yeah. It isn't, as it were, a binary decision.
Yeah.
The fundamental analytical problem, which is why my Lord, I'm sure, had it in mind as incommensurable, the fundamental difficulty with a binary decision is you've actually got to decide how the thing comes out, yes or no, cancel or not. It isn't, we'll now fine £1,000 rather than 999, and anywhere down the range to zero. So we respectfully submit that that's a straightforward apples and pears comparison with penalties at that level.
You're going to deal with paragraph 80 of the Court of Appeal's decision where they allow for an exceptional...
I am. I'm going to come to that at the end. But the third of the difficult features, if one does introduce this into the discretion, is, and I can put this point pretty shortly, and again it's intensely practical, everyone is going to say that. Everyone is going to say that. It's going to be an absolutely standard response. Because
well, everyone's going to be right.
Well, everyone's going to be right. They are. They may not necessarily be right about the conclusion to which it leads, but everyone will be right because it's an inherent feature of the scheme. But the practical concern here is that we all know, if you're fighting this sort of issue, what tends to happen is that someone comes across a taxpayer or group of taxpayers come across, as it were, an arguable point, and the breach in the walls is thereby formed, and then everyone says, I'm an exceptional case, you need to balance it in this difficult way, and the more difficult the balancing judgment, the more scope there is for that. Then what happens is they go off to the tribunal system or the judicially reviewing courts, and they say, we want interim relief. We want it stayed until you sort out our case, or that's the operation of the tribunal regime. But so there is, as it were, an immediate gumming up of the system.
Well, they don't have to do that in this case because there's an automatic stay.
Yeah. Yeah, they don't have to, but the gumming up happens automatically. In other contexts where it doesn't, they go off to the JR court, and I think you've got a hearing coming up in one of those cases quite soon, or maybe the Court of Appeal, where in a different regime to do with bonded warehousing, where the same thing happens, but you have to go by way of JR, as it were. And the question is, what happens then? And the answer is, everyone piles in on the back of it, interim relief is granted in one case, and the whole thing grinds to a halt until this court has ruled. But there's an intensely practical problem with that, which is linked to the difficulty of doing the measurement. So my respectful submission is that those are serious positive inconsistency features which the court can take into account, and they have within them, as it were, the fundamental interpretive point about this feature being extraneous to the nature of the highly prescriptive and detailed regime, which are all to do with compliance, making the scheme work effectively, forgiving when that doesn't compromise the effective operation of the scheme. That's the third point. The fourth point is the one which the Court of Appeal was particularly exercised about, in the sense that it formed the gravamen, I think, of the argument that my learned friend ran below, and that is whether or not the discretion on our conception of it is really no more than a busted flush, because all the circumstances will already have been taken into account in considering the conditions. Put another way, does the discretion have room to operate without, in a sensible manner, under this scheme on our conception of it, without having to take the potential impact on the individual into account? And my submission is, for all the reasons given by the Court of Appeal, that it plainly does. The way in which the discretion works is to temper the rigours of the scheme.
But in the interest, you submit, of the revenue rather than the...
Well, it can be a bit. It can be a bit of both. It can be a bit of both. So the Court of Appeal's reasoning was that that discretion could operate and did operate to some extent to alleviate what would otherwise be the unmitigated rigour of the scheme.
It is a matter of choice, is it? I mean, if you wanted to take into account hardship?
My respectful submission is not. That was the point that my Lord Briggs was on at the outset. Right. We say not.
Yeah.
Because we say that to do so would be inconsistent with the fundamental thrust of the regime. It wouldn't just be, as it were, to introduce factors which are within the contemplation of the scheme and the sort of forgiveness that the Court of Appeal dealt with when it analysed this point. It would be to introduce a wholly extraneous factor of real significance and with real potential disadvantages.
And you wouldn't support an analysis as an alternative according to which it was for the revenue to select the factors which were relevant, and it could select this, but wasn't obliged to. No.
I wouldn't support that.
No.
I mean, there might be occasions.
Mandatory implied disregard country. You're in implied mandatory disregard country.
I am.
I think. Yes.
I am.
And do you say it's implied, or it's to be a matter of construction looking at the scheme as a whole?
It's a question, I think, of if one wants to put it in a public law box, it's a question of identifying the purposes and aims of the legislation, seeing how it was designed to work, and seeing whether or not the introduction of this feature would be inconsistent with that purpose. So it's a Padfield argument. But as I said to you, I think when I answered your question before the short adjournment, one can legitimately start at the other end of that legal spectrum and say test it against mandatory relevant consideration at the other end of the spectrum first. That throws one into an analysis of whether Parliament has expressly made it relevant or impliedly made it relevant. If the answer to that is no, then you've gone quite a long way down the road of identifying the nature and purpose and aims of the scheme anyway.
What if the hardship has implications for the amount of tax that you collect? I mean, there might be cases where the hardship is of a nature which, whether you care about it as hardship, may not matter, but the inland revenue might say, well, if we drive this man out, we may actually reduce the total tax take.
Well, then I suppose you would be taking into account collection with hardship as an incidental feature.
Yes, but you don't, that would be an acceptable way of exercising the discretion, would it?
Well, whether you use this power for that purpose or whether you use some other power for that purpose, I mean, I can see a stronger argument at that stage. I think I'd still be nervous about attributing to Parliament an intention, as it were, to allow it to be taken into account even at that stage, if the consequence of that might be to say, well, there it is, it's just a question of degree, why can't you take it into account?
Well, it wouldn't be quite a question of degree, because the mandatory disregard is hardship in itself. There's no mandatory disregard of considerations that go to the effectiveness of the tax collection system, quite the reverse.
Well, that was, I think, perhaps what I was driving at in saying it's an incidental thing to the
absolutely,
to the broader collection purpose.
It's quite difficult to sort of tie your hands to it. I mean, I'm going back to what the appeal being allowed or the review being allowed. It's clear what happened was the company put in an appeal saying, look, it's jolly hard luck on us. It's going to cause all sorts of problems, and we're doing our best to comply. And the revenue come back on page 85. On this occasion, I'm prepared to overlook these failures. Your appeal is upheld. Now, that's an exercise of some sort of discretion. It's not the revenue saying, yes, you've brought yourself within the statutory scheme. They're saying, I'm prepared to overlook these failures. We don't know what led them to reach that.
We don't, and that's the difficult. I mean, part of the answer to my Lord's question is that you're here as the court of principle to sort out what the right answer is. So
we don't want to sort of tie you down so that you can't do what you did in this case, I suspect.
Well, true, but the difficulty is identifying from the course of that correspondence precisely why it was that they reached that conclusion and whether they truly did or didn't take into account hardship. But the issue that is raised is an issue of principle.
I mean, what seems to have happened, one of the thoughts perfectly reasonable, is that they were they come up with two instances where there's failures, significant failures, and they decide after three that's enough is enough.
Yeah. But that could just as well be a decision, as it were, that because the margins were pretty small in relation to the failure, even though they were outside the statutorily prescribed tolerances, they were then nevertheless prepared, as it were, to forgive those on the basis of clear understanding by the taxpayer that the next time round they wouldn't be so lucky.
Yes, what's interesting, just to carry that through, the way the review works, having looked at section 47A, is 49A,
Yeah.
is if there's an agreement reached, then it results, it's treated as an agreement settling the appeal under Section 54. And presumably, that's something which could happen at any stage. It could happen now. You could say, well, we're going to settle this appeal. You've carried on perfectly well for the last 7 years. We're going to settle this appeal. And is that right?
My lord, as I say, I do it with some trepidation, but I think that's right.
Yeah.
And perhaps the key feature of that reviewing mechanism is that there is, and I think this was the point my lord was interested in before the short adjournment, whether there is, as it were, some freestanding and potentially broader discretion in HMRC sitting within that reviewing mechanism. And I think the way that it's cast, perhaps in 49E, capital E, I think the way it's cast is the revenue shall take into account such matters as they consider appropriate, or wording.
Can we look at that? I mean, my judicial assistant actually made copies for us. I'll hand these.
Yeah,
or possibly,
we've got copies if you need them.
Right. Possibly yours are, I think it was better, but just run through the sections.
I mean, it looks as if the reason for the internal review decision to uphold the appeal was that they felt that there was an excellent chance that it wouldn't be repeated, in which case there wouldn't be a loss of tax revenue.
Yeah.
So when it happens again, clearly that's not a line they can go on taking for much longer.
Right, although they did the next time round, you won't be so lucky twice.
Yeah.
but the complication of it is that certainly in the taxpayers' letters, rather than in the reason letters, there was reference to the consequences and impact and so on.
Just take us through the review procedure, if you wouldn't mind. I hope we've got all the sections. We've got section 49A to I here.
Yes.
54.
The one I was particularly interested in, I hope I got the letter in, it was E, I think, which is that E that has the appropriate? Yeah, it's 49E2 on the point as to whether or not the discretion is broader.
That suggests, that it picks up what I was putting to you, which you don't accept, namely that HMRC might have a choice as to what factors they regarded as relevant. But
my lord, I certainly do accept that proposition so put.
yeah.
My submission on 49E sub 2 is that appropriateness for that purpose must be conditioned by the legislative regime which sits underneath.
Yeah.
It couldn't, suppose a regime which positively excluded a particular feature,
Right.
you couldn't rely upon the appropriate wording to drag it back in under 49E. Right.
So
We've got to remember that these provisions are general, applying to across the whole
Yes.
realm of tax. And
Again, that rather feeds into the same point, which is you take your colour on the review. It's designed to be a mechanism, I imagine, for sorting out obvious error at an early and efficient stage.
Yeah.
But what it doesn't do is to introduce the potential new factors which are either not features of or positively not features of the underlying regime pursuant to which the original decision was taken.
in subparagraph 4, we have to read in that light, do we, where it says the review must take account of any representations made by the appellant at a stage which gives HMRC a reasonable opportunity to consider them.
Yes,
you
insofar,
can-
insofar as
extraordinarily
relevant.
elaborate. I was involved when this was all being done because it was all tied up with the review of the tribunal system.
Yes.
But I must say I hadn't realised quite what an elaborate code they produced.
Well, it's quite an elaborate code, but in the end it's quite simple.
Yeah.
Because its aim and object is self-evidently to try to avoid troubling the tribunals with unnecessary
Yeah.
cases where there is obvious error. But the more fundamental point for our purpose is that there is nothing in this scheme, containing as it does an appropriateness discretion, which could be used legitimately to broaden the discretion which is properly to be exercised under the underlying regime.
What does section 54 say? I'm just looking at, it's referred to in 49F. Do we?
It's just a general...
That's settling appeals by agreement.
Yeah,
I see.
settling by agreement.
Yeah.
It just provides a mechanism for bringing it back into the statutory scheme.
I'm told that if one, I mean, again, I don't want to get too sucked into the underlying facts, but there may be a hint of reasonable excuse in some of the correspondence when they forgave the first time or the second time.
I see.
But I mean, it matters not for present purposes. Well, I hope I can leave that bit of the discretionary scheme
Thank you.
there. It exists for good reason, which has got nothing to do with expanding the nature of the discretion in the underlying scheme, is the short point. So come back to this issue, which is, does the discretion have room to operate, even if you leave the potential impact out of account? And my respectful submission is that it plainly does. Firstly, you don't need to take impact into account to explain the discretion. The requirements of the compliance test and the exceptions in Reg 32 are highly prescriptive, as we've seen, and it's easy to think of the exercise of the power in circumstances which would be appropriate, not extraneous, and nevertheless where those conditions have not been met in some way. And both the upper tribunal at 64 and the Court of Appeal approving the two examples that they gave at 63 highlighted those features. And in doing so, I think the two examples they gave were, firstly, the late filing of annual accounts at Companies House. When we looked at that, that was Schedule 11, paragraph 12.5, where HMRC formed the view that it wouldn't be repeated if they were a day late or whatever it may be. And note that that example is one of those where the compliance requirements do not attract the reasonable excuse exception. That was the point that Lord Justice Henderson was making. So any single failure, even if there is a reasonable excuse, will be fatal to the exercise of the discretion, as it were. That's the Court of Appeal, paragraph 63 point. And the second was where they were late filing a return in circumstances where there was no reasonable excuse, but because that is one of the conditions, but HMRC was satisfied there would be no repeat given changes in the systems of the taxpayer. And one can multiply the examples. One can do it by reference, for example, to the turnover of a company dropping for exceptional reasons, so that the turnover test is narrowly missed, but there's reason to suppose that the turnover of a company will increase in due course. I mean, suppose they're paid up front in a long-tail contract or a long-term contract and the cash flow in later years drops, or supposing the manner of payments indicates that the cash flow graph is going to go up and down. Or suppose that there are unforeseen changes in the relevant legislative regimes. I mean,
is a headline way of putting it, these detailed provisions are designed to tabulate, if you like, as far as can be done up front, the risk of loss to the revenue arising out of the risk for which this scheme was put in place to deal with.
Yeah.
There are bound to be situations where, A, there is a risk even though there's full compliance. Nothing you can do about that, I think.
And the reverse.
But also, B, where there is some very small non-compliance, but actually, for other reasons, no risk. And I think all the little examples you're giving are really examples of that second situation.
They are. My Lord, can I agree with you and take the point one step further on, which is that there was some suggestion, I don't know if it's still maintained, that, as it were, history disproves our case. Because you'll remember that originally in this setup, there wasn't, as it were, the detailed prescription of the kind that you just described in the Reg 32 examples, and there was simply a minor and technical failure exercise of judgment to be made by HMRC, and obviously that led to lots of litigation about what was minor and what was technical and all the rest of it. What Parliament then does in our scheme is to introduce things like Reg 32. And what that does, as my Lord has exactly rightly described, if I may respectfully say so, is to introduce, as it were, advanced prediction of those sorts of failures, to prescribe them very tightly, to prescribe exceptions to those conditions, and to do all of that. But it was not necessarily intending, and nor, it might be thought, could it sensibly intend, to cover everything forever in doing that. And so that is not in the least bit inconsistent with the existence of a residual discretion. And the question is, how narrow or wide should that residual discretion be? And at that point, the degree of prescription comes in to assist in concluding that it should be narrow. And one can make the same point about impact. It's introducing an enormous great area, which it would be deeply surprising is not covered if that was truly the intention.
And does it flow out of that the boundaries of that discretion, it's your Padfield point, are those which are genuinely material to the risk rather than those which are wholly at right angles to it?
My Lord, it does, and I think that's the essence of Lord Justice Henderson's reasoning in the Court of Appeal. Yeah. And the challenge that he was confronting, that I'm confronting now, by strongly and respectfully agreeing with his analysis, is you can make the discretion work in a perfectly coherent and sensible manner, even if it's narrow. So that's the first of the difficulties, or first of the ways in which it's of interest, this discretion. And secondly, it may be thought, there would be, at least potentially, some serious practical difficulties if Section 66 on cancellation were to be cast as a duty. And again, it's not very difficult to envisage those. Whether or not the process can be, as it were, managed in a sensible way, all other things being equal by the revenue, I don't doubt that it potentially could. But the difficulty that arises in an industry like this, with a scheme like this put into it, it's almost inevitable that one competitor is going to be on the back of another competitor. And they're going to be saying, well, what about this? They haven't done that. Why are you not taking that away? It's a duty. And so you end up with all sorts of potential issues of the revenue, as it were, having to deal with the hard-edged nature of a duty, whether at the instigation of competitors within the industry or otherwise. And so the core points in the end on this bit about how does the discretion work are firstly that there's no need to widen the scope of the discretion to cover financial impact. It can operate perfectly satisfactory without, as the Court of Appeal put it in 63, travelling outside the proper scope of the power. Secondly, that condition, discretion is, we respectfully submit, obviously conditioned by the surrounding nature of the regime and the things to which it directs attention and the aim and purpose of the regime. And the third thing is that it is one thing for it to operate in that way and quite another for it to operate to require financial impact to be taken into account. The fifth and sixth points I can take much more shortly, and they are to some extent, as it were, a precursor to the A1P1 arguments. But the fifth point is that there are, and I do respectfully submit that this sounds in pure domestic interpretation rather than simply A1P1, there is a series of protections built into the legislation. And what that means is that there's no reason to ascribe to Parliament a necessary intention to render impact mandatory, because without it the scheme would operate with extreme harshness. That's really the thrust of the point on domestic interpretation that the Court of Appeal set out at 59 of their judgment. So substantively, the legislation introduces tolerances itself, some form of forgiveness in the express terms, for example, of timing in Reg 32, which we've seen, or for some defaults where the reasonable excuse provision applies. Secondly, not obliged to make a decision to cancel. There is the capacity for discretion to be exercised favourably to the taxpayer. And thirdly, the taxpayer can apply, albeit after a year from cancellation. And Parliament was obviously within its margin to bring in a period there, otherwise you'd have repeat applications. So substantively it provides a range of protections, and so it does procedurally. You've got to give notice of the cancellation with reasons under this scheme. Protections are built into the initial compliance test are then indirectly, as it were, imported into the cancellation scheme, and there is a right of appeal under Section 67. And the proper way to view that structure and those safeguards we submit is that they are themselves in place in recognition of the inevitable adverse impact on the taxpayer. The privilege is a privilege. It carries benefits. And these safeguards demonstrate that those have to be borne and the safeguards are commensurate with that. The sixth point is that there is no undue harshness in the operation of the regime if the revenue do not have to take into account the potential impact on the individual taxpayer. And that is because those who are involved know the scheme. It's set out in detail on the face of the legislation. They know the steps that need to be taken to ensure that compliance continues to be met, and those conditions are not onerous. They are administrative efficiency and carefulness. And moreover, the taxpayer is fully aware from the face of the scheme of the consequences of not complying. And it might be thought that the more serious the potential impact on the individual business, the more clear it can be taken to be to the taxpayer that they thoroughly need to comply.
Is there any other aspect than turnover in which these conditions are all in fact part of the law anyway? The Companies Act obligations are all legal.
Already.
And the tax obligations, one assumes, are all legal requirements. I'm trying to think if there's anything else in the table
within the
of
conditions
other than turnover.
Yes, I'm not sure there is because the other ones are Companies Act and NI contributions.
They're legal requirements.
They're all legal requirements. And then PAYE and all the other tax obligations. So it is, as my Lord says, just complying with the law, but doing so carefully. Yeah, my learned friend reminds me the business needs to be carried on in the UK, but that's, as it were, a threshold requirement. And so the short point on undue harshness is that avoiding the cancellation of the privilege lies readily and without real difficulty in the hands of the taxpayer. It will have, as the Court of Appeal put it, nobody to blame but itself if its registration for gross payment is cancelled. And here the evidence is clear about the number of opportunities that they were given. So the conclusions on the statutory scheme, perhaps if I just pause before the conclusions just to see whether maybe a couple of points just to pick up in response to my learned friend's submissions. I've dealt a bit already with penalties, and I dealt with the aspect in answer to my Lord, Lord Mance's question about whether they're the same and the range of and how discretion operates in relation to those. But I think a separate point is made, which is that they are said to show, or the existence of the penalty regime itself is said to show that hardship is, as it were, not an extraneous factor because there is a penalties regime. But my respectful submissions on that are that are firstly and principally that that's in truth an apples and pears comparison at the basic level of the nature of the regime, including within that the fact that our scheme is on any view not a penal scheme. It is a collection scheme, and it's designed fundamentally to protect the nature of the revenue's ability to collect tax. In any event, extraneous or within a scheme is plainly to be judged in the context of the particular regime that you're talking about. And the regime here, as I say, does involve collection of tax, not penalisation of tax, and there are plainly differences in aim, purpose and function at the basic level of the scheme. Secondly, and in any event, at a level of greater detail, any penalty issued would be issued under Section 72 of the Finance Act 2004. I'm not going to go back to it, but Bundle 1, Tab 7, page 281. And in relation to the CIS scheme, that is subject to a specific power in Section 102 of the TMA 1970, Bundle 1, Tab 2, page 232, which provides HMRC with the express power to mitigate any penalty or stay or compound any proceedings for a penalty, and may further mitigate or entirely remit the penalty. So there is no equivalent power in section 66. So if anything, the existence of that separate regime with that specific statutory permission is a point in our favour rather than against us. So in conclusion, on the statutory scheme, it doesn't expressly require this feature to be taken into account. That isn't a neutral feature. It would have been the easiest thing in the world to do. Indeed, one would have expected Parliament to do it, given the real controversy of and difficulties associated with introducing impact into the discretionary judgment. And it plainly doesn't do so impliedly, we respectfully submit, for all the reasons I've given. And thirdly and finally, it is entirely clear what the aim and purpose of this collection scheme is, and to introduce that sort of feature for the 6 reasons that I've given would be to cut across the fundamental purpose and nature of this scheme. So that's the domestic position. Can I turn briefly in the time that remains to A1P1? And to make the point, perhaps right at the outset, that the premise for the A1P1 claim is that we are right as a matter of domestic interpretation of the aims, purpose and effect of the scheme. Because if we're wrong, they don't need it. But the 2-stage analysis, sometimes broken into 3, sometimes ignored entirely because lots of these features merge into each other, are interference or possessions, interference, fair balance. And it is perhaps of some significance that the court does sometimes, as it were, go straight to fair balance, because certainly in relation to some of the points I'm going to make about conditional rights, that is a point which, even if it doesn't work, as it were, under interference with possessions, plainly is of significance when one comes to consider fair balance, with on the one side the general interests of the community, and on the other side the question whether or not the individual is bearing a burden which is excessive or harsh. And if all you're doing is operating the conditions which they knew full well existed, then you're unlikely to fall within that, favourably within that balance. But first of all, to deal with interference with possessions, and just to identify the relevant features that we're here dealing with, we're dealing here with collection of tax and not its imposition. So the subcontractor always remains and will always be liable for whatever tax is properly due from it. And when this is accounted for by the contractor up the chain, it operates as a credit against the tax liability of the subcontractor. In this particular scheme, it is plain that under the relevant legislation, Section 63 and following of the Finance Act, the default position has for many years been that the taxpayer receives the monies it receives under deduction. I call that the default position because the only alteration to that position occurs if and for as long as the taxpayer complies with the strict and express conditions of the regime for gross payment. And to cast this into Strasbourg language, it's quite clear, we respectfully submit, that there could be no conceivable argument under the Strasbourg concept of legitimate expectation. And you know from the case law how they analyse this. They tend to look to see whether there's a properly established right, so-called under domestic law, or is there an expectation that a benefit, a legitimate expectation, is the language that Strasbourg uses in a slightly different sense, but with obvious similarities to our public law concept. Is there a legitimate expectation that the benefit will continue? And so those are the key features, it might be thought of this regime, with all the conditions fully laid out, all the exceptions fully laid out, and the existence on the A1P1 argument of a discretion, but a discretion that doesn't allow impact to be taken into account. That's the nature of the context. Possession and interference are, of course, analytically and theoretically separate concepts, but they are obviously, and particularly obviously in a context such as this, closely related to each other. And the nature of the submissions that we make can be analysed either way, perhaps more easily as interference, but could be done either way. Focusing on the full contract price way of putting the thing to start off with, and the situation in which the taxpayer does not get the full contract price any longer because they have reverted to the statutory default position in the event of their own failure to comply with the conditions. Now, so far as the full contract price is concerned, no doubt in an ordinary context, the price that you are entitled under a contract to receive would be characterised as a possession by Strasbourg. No question about that. It's a right under domestic law. And you say, thank you very much, there's the right. If the state comes along and says, right, I'll have that, that would be a deprivation of a possession. So shows in action can be possessions for the purpose of the Strasbourg case law. But here, I don't know what the contracts say. I'm not sure anyone's ever seen any of the contracts that actually exist, so far as this is concerned. But it is a remarkably safe assumption, I respectfully submit, that it is well understood by all who entered into that contract, and was plainly the contractual intention, that if the person concerned, that is the taxpayer, the subcontractor, ceased to be registered, there would have to be a deduction from the full contract price. It's a matter of pure contract. The position can't have been otherwise, because this is a statutory scheme in which they are operating. Tested in this way, suppose registration drops away, they are no longer registered to receive gross payment, and at that point the subcontractor sued the contractor and said, I want the full contract price. The answer would be, well, the intention under this contract, irrespective of whether it contains express terms to this effect or not, is that we will operate all this contract in accordance with the law, and under the law we're required to deduct before it gets to you. So there is no contractual right in all circumstances to receive full contract price. As a matter of pure contract, the right must be conditional upon the continued satisfaction of the statutory preconditions to their receipt of gross payment. And the same analysis and the same answers flow if one simply analysed it, as it were, as a bundle of rights or a bundle of benefits. Of course they have, and I mean, there may be esoteric debate around whether 3 months' worth of cash flow can properly be described as a right for the purpose of the Strasbourg jurisprudence, but the same point applies. Even if in theory those things could be possessions, how can it possibly be said that there is interference when the only circumstance in which that cash flow benefit will be removed is the circumstance in which the taxpayer has failed to comply, or there has been a failure to comply with the statutory conditions to its continuation? It isn't a fixed set of benefits. There isn't a right to continue to receive them, however badly you default on the conditions. And as I say, you can analyse that as no possession, or you can analyse it as in theory a possession, but no interference. But the point is effectively the same, and it does come down to the well understood and clear conditionality of those rights. Now, that's the way the argument works in principle, and it's an argument that sits in a very, very specific context where one's not dealing with the imposition of tax, we're simply dealing with collection and mechanisms of collection, but that's how it works. But the case law you do need to appreciate, because the case law, to put it with as much politeness as I possibly can, is at least in the Strasbourg court, is not entirely clear as to quite how these schemes work. I know at least some of my lawyers will be very, very familiar with how this sort of setup works, and the first case that normally pops into one's mind when you have something that is at least arguably analogous to a licence is trade tractory, and that line of case law about licences and removal. And the position, as I'll show you, and it's right that I should show you it, because one of the new cases we've put into this little black bundle is a case called Viconi, which is perhaps the high point of the case against me, as it were. But it's right that you should see that. But before we get there, can I just take you to our own top court in Wilson and First County Trust, which, as you'll recall, was the consumer credit case. And here again, this issue appears to have caused some little difficulty.
What's the reference?
I'm so sorry, my lord. It's bundle 2, tab 20, starting at page 500. I hope I've read it correctly. I think on this point I make it 2-1 in my favour out of a 5-judge court. But if I've got that wrong, someone will tell me. Lord Nichols, or just about, possibly 2-1 against me. Lord Nichols, if you start on page 517 at para 28, just for the purpose of seeing the nature of the issue and the framing, as it were, for the possession argument in that context. Can I invite you just to read?
What page? 517.
517, para 28.
Yes.
Just setting out the key features of the Consumer Credit Act regime. So in relation to certain types of agreement caught by that regime, there were statutory preconditions that were designed to protect the consumer, and if they weren't complied with, because, for example, there was improper execution of the agreement and it didn't contain all the relevant details, under the statute, 65 sub 1, as one sees by the letter G on page 517, the consequence is that the agreement is not enforceable against the debtor save by order of the court, and the court has various discretions and so on. So there was then a debate about whether or not Article 6 applied or Article 1 of Protocol 1 applied, and just to pick up the relevant bits, in the speech of Lord Nichols, para 40 and 41. So I'm taking him, for my purposes, as being against me on the scorecard.
You might say that the third sentence of 41.
Second. Yeah, third. Yeah, exactly.
He's not that far against you.
That was going to be the writer. Although, query how far that goes. It's expiry of a limited interest in accordance with its terms and so on. But yes, I agree. But subject to that, I'm prepared to take him against me, subject to that point. So that's Lord Nichols. Then Lord Hope, who gives the second speech, and he is, as it were, flat against that. And his reasoning, one sees encapsulated in 106 and 107, but you can probably start 106 between the letters D and E on page 538. One must, of course, distinguish carefully between cases where the effect and so on. Could I invite you to read from there to the end of 107? So he's for me. Lord Hobhouse, I think it's fair to say, goes off for this purpose on I was about to say a frolic of his own. perhaps not a natural frolicker, but 136 to 137 are where he deals with possession, but I don't think any of that really touches the debate between Lord Nichols and Lord Hope. And so, moving on to Lord Scott, 168, and Lord Scott is with Lord Hope.
Sorry, can you
Lord
give me
Scott,
that?
168 on page 556.
Thank you.
And then finally, Lord Roger.
Yes. Sorry.
Finally, Lord Roger, but Lord Roger is a long and extremely learned judgment about how the Human Rights Act works and doesn't actually...
It's not a very helpful authority, this is it.
It's not an enormously helpful authority, but
I was looking at the head note, which seemed, not sure, at paragraph on page 501, paragraph 3,
Yeah.
which leaves it pretty obscure as to who decided what. But
And one, if I may say, if I can say so respectfully, one can understand a degree of caution in the head note writer as to this point. But those are the bits that deal with this issue, so one can see, as it were. I'm not
is
placing
it
great
the same
value.
issue? I mean, here your simple point is that you can only discover what the right here is by looking at the statutory context.
My Lord, that's exactly right. But I wanted to show you that just so you had it on this debate, because it's about conditionality, it's about a pre-existing scheme, even though it might be slightly different to our situation.
Can I ask you another? I mean, I don't know whether you're coming to this, but the specific provision in Article 1, Protocol 1, which says this shall not interfere with the
taxing.
enforcement of tax.
Yeah.
Do you attach importance to that?
I do, but I don't for the absolute purpose for which it was floated this morning.
No, I mean, I was
It's marginal.
reminded of a case called Lindsay and the Customs Commissioners, which is in the bundle in Authorities 1 at 19, where I was in a court of appeal which actually considered this. That's at MS 495.
Yeah.
And I mean, that was, of course, a rather different context of the very draconian customs sort of legislation.
Yeah.
But we seem to have taken the view at page 495 that really the specific reference to securing payment of taxes didn't really detract from the general approach of applying proportionality tests.
Then I'm in the luxurious position of saying, my Lord, I agree.
You do.
I do. I don't rely on that second paragraph as being, as it were, an absolute shutout. It's plain from the case law in Strasbourg, including the classic national provincial,
Yes.
and with all that line of case law, that it goes to margin. What it does emphasise, because it's specifically split out, and this, I think, is the essence of the reasoning in Strasbourg, is that you have a particularly wide margin there. It doesn't, as it were, remove the need to consider proportionality in that sense.
And it may have more relevance where you have a fairly narrowly defined statutory scheme as here, as compared to the very broad powers you get in the customs legislation.
Yes, and I'll come to the to the points that have been made about general measure or not general measure in a moment. But my Lord, for that purpose, I agree. It's margin rather than absolute shutout. I was going to take you to the Strasbourg Authority, which perhaps analyses this sort of issue most closely, and it is J.A. Pye Oxford Limited in the United Kingdom, and it is at tab 60 of your little black bundle. And what I'm taking you to is the Strasbourg Court at first instance, as it were. This case went to the Grand Chamber. The Grand Chamber effectively said on possessions, we agree, and did so in pretty short form. So this is the analysis, as it were. subsequently in effect adopted by the Grand Chamber. And the key paragraphs for our purposes, and you may be more rather than less illuminated at the end of them, but I'm going to make a couple of short points on them once you've read them, if I may, are paragraphs 49 through to the end of 52. So 49 on page 57, top right-hand corner, paragraph 49 through to the end of 52. Not for me to comment on the coherence of that distinction, but what they are plainly doing is to draw a distinction, see the penultimate sentence of para 51, between a law in question which is properly to be seen as qualifying or limiting the property right at the moment of acquisition, or, and this is on the other side of the distinction, whether it's rather to be seen as depriving the owner of an existing right at the point where the events occur and the law takes effect. So, as it were, there's general legislation floating around, and then there's a right, and a particular event occurs that triggers the
Doesn't it correspond with one's feelings? I mean, if you have property under a lease or a contract, you expect to find the terms there, you've agreed them, there's a close link, whereas if you wouldn't say, I hold my property subject to the Prescription Act.
No. That appears to be exactly the distinction that is drawn.
Yes.
Thoroughly delighted if my lord thinks it's...
Well, I don't think one thinks of the Prescription Act, and probably are not aware of somebody squatting there.
Quite, as necessarily cutting in. That seems to be the sense of it, and there may be good justice in that, as it were, not least at a very base level, because
Limitation Act or whatever.
The closer they are to being conditions that are obvious and up there at the time you take the property, the more unattractive it becomes to say, I didn't really realise it was going to happen, if those conditions then occur. But you see that's the distinction that's drawn penultimate sentence of 51, and you see also as you go through 52 that what they do in the second sentence of 52 is to distinguish from the case that they were considering in Pi. They distinguish the case where there is a grant of licenses which were from the outset subject to conditions imposed by law, which were either never fulfilled or which ceased to be complied with. And so those, as it were, are, from my perspective, on the right side of the line for the purpose of this distinction. And you see that the cases that are cited at footnote 23 include the case that we cite in our case, JS Netherlands, which was a case about licenses and milk quotas, and it was obvious how the milk quota worked. So that was JS Netherlands. I think Zacher in Germany was another milk quota case where it went with the land, and Gudmundsson in Iceland is all about taxi drivers no longer fulfilling the conditions of their licenses, and so the taxi licence is withdrawn. So they distinguish that line of case law where the licenses contain their own conditions and those conditions cease to be complied with. So it's a subcategory of licenses to which that principle applies.
Is there any distinction between a licence which terminates automatically because the condition is not complied with and, say, a forfeiture clause in a lease which effectively gives the landlord a right, if he chooses to exercise it, to bring the interest to an end, subject obviously to court supervision and control?
Well, that's not entirely clear, but I respectfully submit that the essence of this distinction is perhaps most readily found in the clarity with which the conditions are set out and the point at which it's clear to the individual concerned that they take the property, but only subject to that. Now, again, that may lead to difficult examples and then, or not, but precisely where one draws that line may be debatable, but the things that they specifically put on, from my perspective, the right side of the line are those cases where the licenses themselves contain a condition which ceases to be complied with, whether through effluxion of time or through the failure of the licensee to comply with them. And they also distinguish Wilson and First County Trust. And they do so, and the government no doubt relied on this. I think it was Jonathan Crowe who was arguing this case in Strasbourg and who was counsel for the government in Wilson and First County. So he obviously relies upon that in this context to say, well, there's the majority of the House of Lords saying conditional rights, and they distinguish that as well. And the way they do the distinction is by saying, as you see, 2/3 of the way down 52, the position that they had there under the 1925 and 1980 Acts are, in the view of the court, to be seen as biting on the applicant's property rights only at the point at which the Grahams had completed 12 years adverse possession of the applicant's land, and not as delimiting the right at the moment of its acquisition. So it's conditions set out from the beginning. Everyone knows that they're there and they're not complied with. That's not an interference with property. On the other hand, if you've got general law which cuts in on the happening of an event sometime after, that could be, is the essence of it. My learned friend placed some reliance on the Manchester City Council and Pinnock case, which again I know some of you, certainly Lord Mance, will be familiar with. And perhaps the only thing to say about the Pinnock case is, perhaps two things to say about the Pinnock case. One of them is that it involved removing public sector tenants from their house, from their home. So pretty serious concern under Article 8, and the question is whether proportionality had to be taken into account, irrespective, as it were, of the statutory regime. Answer, yes. And no great difficulty with that. It looks as though there was a bit of a struggle or a bit of dialogue between the courts here and Strasbourg before eventually, as it were, the conclusion in Pinnock was reached.
It certainly was, yes.
But as my Lord may also recall, I can't remember whether I don't think you were on that court, but my Lord Carnworth was. There was a follow-up to that in a case called MacDonald, if you recall, which was about the legislation governing private sector tenants, and whether or not we could have equivalent legislation that says there's an absolute right to get possession if you're a private landlord, without taking into account Article 8. So one can see the attack. You said it in relation to public sector tenants, so why doesn't the same logic answer, different answer, because different balance. But all that those cases illustrate is that you have to consider the particular context. None of them are remotely equivalent to our sort of case, and none of them establish the sort of generalised proposition of principle for which my learned friend intended. So that is the development, as it were, in our law to the extent it's relied upon. The case I did want to take you to was Vacconi, and that, I'm afraid, I'm not sure we'll have a number, but it'll be at the back, somewhere round about the DSD decision that you looked at earlier. The front page, I'm hoping it's a bit like that. So it's got a little bit at the back of the file.
So what's the name?
Vacconi, yes, it is.
Vacconi and Hungary.
It is the second one. It's after MKM and before McDonald.
I'm very grateful. And I wanted to take you to that authority, a case of the decided by the second section. This was about taking away a license to sell tobacco when the tobacco legislation in Hungary got tightened. You get a flavour of the facts, and I think it may be quite important that you at least get a flavour of them from paragraph 6 on page 2, page numbers on the top of the page. From, if you just cast an eye down para 6 through to the end of para 10, you'll get a sense of what the Hungarian system was, and in particular, the rather more generalised nature, as it were, of this sort of licence, and the legislation then cutting in, as it were, unexpectedly or otherwise sometime afterwards.
Right.
So, as I say, this isn't a case of a licence with a set of specific conditions which are then subsequently not complying with. There was a general licence to sell tobacco and alcohol. The tobacco legislation is then subsequently tightened up, and then there's a review of licences in effect, and the decision is taken not to renew this individual's licence, as it were. So that feels a bit more like general law, is the submission. But you see that this is an example of a line of cases where Strasbourg has at least tended to say, and sometimes they introduce valid licence and sometimes they say long-standing licence, but it's an example of a line of Strasbourg case law where they have said, well, if you've got a licence, what lies underneath the licence in terms of general and business activity can constitute possessions for the purpose of A1P1, and if that licence is removed, that's an interference with those possessions so constituted. And that's paragraph 29 in this judgment. So neither in this case nor any of the cases that they cite there, some of which it might be said, if I was being entirely fair about it, didn't involve any argument at all about possessions. I mean, in Capital Bank, for example, in Bulgaria, it was actually conceded. That's one of the cases you got.
Sorry, what are you referring to? Where's that?
Capital Bank is referred to halfway down, para 29.
Yes.
But the point was there conceded. But there is a line of case law which simply says, as I say, at least for some types of licence, if you take it away, you thereby interfere. But my respectful submission is that none of that actually grapples with the logic or the reasoning or the conclusion of case law such as J.A. Pye Oxford, which is frequently cited in these cases, but for a slightly different purpose. See, for example, the last subparagraph of 28 in this very case. But none of this analysis grapples with the situation that they were there dealing with, which was a licence which is brought to an end, not as it were by the operation of general law or a review of the system, but because the person fails to comply with the very conditions set out in the licence, which I respectfully submit is a much starker case altogether, and a starker case yet in our context, because we're not here dealing with a pure licence, as it were, which permits economic activity. We're dealing with a licence which is to do with tax which is otherwise due. But it's right to acknowledge, and it's right that you should see that, as it were, short form and brief type of reasoning, because there are cases in which it's that light, as it were. My short submission is that it doesn't grapple with or undermine the reasoning that we saw in J.A. Pye Oxford, which is consistent in broad terms with Wilson First County Trust and is correct in principle in my submission.
It's also quite interesting, paragraph 36. The court finds it necessary to put it very high before coming to the conclusion there was a breach. It finds the scheme verged on arbitrariness and was unfair as between licence holders, objectively diminished the chances of the incumbent because others were given 5 licences, and lacked transparency and so on.
Yes, and you won't be surprised to know that when the plain packaging of tobacco in our jurisdiction went to the Court of Appeal, I don't think it ever came here, but the removal of the ability to put trademarks on cigarette packets, this case was the subject of intensive debate for understandable reasons for precisely those sorts of things amongst others. But the facts were pretty extreme. You've only seen a snapshot for the purpose of this argument, but I agree, they put it and need to put it high there. And that's all part of a piece with other similar types of case where law is tightened in order to conform to a greater public interest. You've got cited in the paragraph above the one my Lord identified, you've got all those cases flowing out of the bovine spongiforma disaster and the tightening up of the regulations that applied, which rendered a whole bunch of machinery, OTOs, and the value of the business went down. And you've got Ian Edgar Liverpool, if I remember correctly, that was about banning handguns in the aftermath of Dunblane. Same effect, lots of shooting galleries.
So if we examine the cases in paragraph 35, you say they're different in nature.
Different in nature, but supportive in terms of the broad approach, which is a broad margin in setting up these sorts of schemes.
That's supportive of a broad approach, yes.
But I thought it was right at least to show Vacconi, because on possessions, sometimes they just do it short form and say it's taking away a possession, that's the end of that. But I respectfully submit that the true and better analysis is the more considered one in J.A. Pye, and takes account of the fact that you're terminating for a reason, which is the breach of a condition. So that's interference with possessions, and as I say, I put the case on no interference with possessions, but even if there is an interference with possessions, those sorts of features, in other words, the fact that in this case, the license, if that's properly the way of describing it, the benefit, the privilege, is withdrawn because of a failure to comply with the legislative conditions, I respectfully submit that that is something which can feed into that fair balance question. I can turn to fair balance as the last of my topics in the period that remains. Wide margin, I don't need to address you on at all. I respectfully submit that it's absolutely clear on authority and from the structure of A1P1 with its specific reference to tax that there is a very broad margin to be accorded in the design of a scheme of this kind. So far as the application of that is concerned, the case against me has to be, I think, that it is not open to Parliament under A1P1 to decide to set up a scheme of this kind unless the impact on the individual taxpayer who is in breach of the conditions is taken into account. And that collapses when you make the wide margin real and ask the question as to whether or not such a decision could be characterised as being without reasonable foundation. I'm not going to get into that debate around margin and that, but the wide margin has tended to lead to that formulation. In other words, is that scheme is set up by Parliament without reasonable foundation. That is reflective of the wide margin. And in relation to that, I make 2 submissions. Firstly, Parliament's judgment is that this prescriptive and stringent scheme, without impact on business being taken into account, but with the narrower degree of forgiveness on our case that exists within discretion, is the necessary and appropriate scheme. That is in order to ensure that in this context, with its serious evasion problems and history, the collection of tax is effective. And under that system, cancellation simply depends upon failure to continue to meet the conditions which need to be satisfied for the privilege to be granted and to continue. And on our conception of the statutory scheme, those conditions are aimed at ensuring that those who can benefit from the privilege are those who have demonstrated that they are reliable and trustworthy in conforming carefully to their tax obligations, amongst others. And they are so aimed for the obvious reason that only that reliability and trustworthiness indicates that the problems that the scheme as a whole was designed to meet will not arise in the case of the 10% who are afforded that privilege. And there's nothing unreasonable in the system making the privilege conditional on that. And within that scheme, for all the reasons I've given, financial impact is not a relevant factor, I submit, or to introduce it would not be consistent with the purpose and overall aim of the legislation. That's the premise for this A1P1 debate. And that is because it's extraneous. It's got nothing to do with reliability or trustworthiness. And indeed worse, if it is introduced for all the reasons I gave, it risks compromising the effectiveness to a greater or lesser extent of the scheme. That's the public interest side of the balance, which is perhaps no more than a recitation of the points I made in relation to the statutory scheme anyway. And secondly, which is really my points 5 and 6, looking at the other side of the balance, we know that the Strasbourg jurisprudence asked the question under A1P1 whether the individual has been made to bear an excessive burden. So if a public interest benefit is achieved by imposing a particular penalty or difficulty on one individual when lots of people will benefit, that causes alarm bells to ring under A1P1. But here, there is nothing excessive about the individual burdens imposed under that scheme. The default position is the payment of tax under deduction, and as you know, the scheme, as it were, goes from gross to one type of deduction to another type of deduction, but gross is ultimately the privilege that is to be earned and maintained. All the points I made under my points 5 and 6 when addressing you on the statutory scheme apply. It's got built into it a series of safeguards. The taxpayer knows the scheme. The taxpayer, if you will, holds the keys to that kingdom entirely in his own hands. And that approach, we submit, is consistent with the case law. And the case law acknowledges that schemes can be set up in this way, which include measures of general application. In other words, for the purpose of our scheme, a scheme in which the revenue positively does not take into account impact because it's extraneous to the effectiveness and proper operation of the scheme. That's what we mean by general application. And it is no answer to that for my learned friend to say, well, yes, but it imposes a discretion. True, it does. But the argument that we're having is what is the breadth of that discretion? And the premise for the A1P1 argument is that that discretion positively does not include, because that's what Parliament intended, faithfully promoting its purpose, positively does not include impact. And if that is the position, that is plainly a position of general application, because it says this is irrelevant to the scheme. It doesn't need to be taken into account. It can't be taken into account under this scheme. That's how Parliament has chosen to set it up, with that, as it were, outside the proper perimeters of the discretion. That is plainly a measure of general application. And indeed, the fundamental fallacy of the case that my learned friend put on A1P1, I respectfully submit, became evident because she was constrained to accept, as it were, that if the scheme had been set up so that it was either mandatory or it said positively and expressly, we say that's the same effect anyway, thou shalt not take it into account, that perfectly obviously would be a general measure and the margin would apply and you would be in that territory. But the position cannot be any better for the taxpayer if the severity of that position is mitigated, and mitigated for good reason, by casting it as a discretion. It just doesn't make any sense. The position is more forgiving to the taxpayer because the discretion is introduced rather than less. So jolly hard to see how that could tip the proportionality balance in their favour. But in any event, if this is truly a point that was designed to go to whether or not this is a general application thing or not, it plainly is, because the premise for the argument is that Parliament has in effect set its face against financial impact being something that the revenue takes into account in operating this scheme. And as part of that, it may be, it's perhaps an aspect of that point, that's the big answer, as it were, but to the extent that my learned friend directs you to a series of authorities in which the individual impact of a particular decision in very different contexts is taken into account in the Strasbourg or the domestic case law, we respectfully submit that that doesn't help her at all. To the extent that there is a need, as it were, to take into account the individual, the existence of the discretion on our conception of the statutory scheme already does that. It allows you to take into account the position of the individual and the position of why it was that they breached, whether they could be trusted, and so on. It isn't entirely general in that sense. All it does, under our conception of it, is to cut out from consideration the extraneous matter of impact. And whatever else they do, the cases that my learned friend relies upon cannot possibly be taken as establishing the general proposition which she had ultimately to contend for, which is that you always need to take into account not merely the individual circumstances of the particular person who is affected by a measure, but the financial impact upon them. Sometimes that may be done. That may be an incident of the A1P1 analysis, but that is nothing to the point. So we respectfully submit that it is entirely open to Parliament as a general approach to set up a scheme which is strict, which is prescriptive, which allows for the limited exercise of discretion, as we submit it is, but nevertheless to cut out financial impact as extraneous and possibly damaging to that scheme. That's a legislative choice. That's precisely where the margin should cut in. And if the margin is broad, that is the end of it. Well, those are my submissions.
Thank you very much indeed, Mr. Speedy. Mr. Ribbett. Thank you. Mr. Chaka.
Well, the revenue say that only has submissions at section 60. Oh, sorry. The revenue said that 66 is the mirror of section 63, and we say that this isn't right, or rather, this is exactly what you have to decide, is how much the question in section 66 is the same as the question in 63. Because if you cease to meet the conditions of grant, you don't lose your entitlement to gross payment status, you become subject to a power to revoke your entitlement to gross payment status. Parliament clearly thought it was sometimes appropriate for someone to keep that status even if they failed the tests. So the fact that you don't meet the requirements of this tick regime doesn't exhaust the decision process for the revenue, and you need to decide what that decision process is about. At one point, the Crown said, I think in passing, that the core purpose of that power is to cancel gross payment status. That in itself might be what the power does, but it doesn't tell you anything about the parameters of the decision. They've taken you to the War Boys case, an example of the line of authority on things which are either mandatory considerations or things which have to be, or which are kind of optional. And I think it was pointed out that this is a case about things which you aren't allowed to take into account. Forbidden considerations. And of course that's the case because the revenue believed they weren't allowed to take into account. You can tell this from the appendix at page 218 where they explain their reasoning on review. They say we're forbidden from taking this into account, and it was the first tier tribunal's finding as well, page 191 at 63. It's also from the statement of issues and actually the pleaded cases, it's clear that this case is on, that it's a forbidden consideration. My understanding is that Mr. Eady's response to that was, well, once you've found that this isn't a mandatory consideration, that gets you a long way towards telling you that it's not within the intended scope of the decision process, and so on a Padfield basis, it's probably an irrelevant consideration. But that reasoning seems to wipe out the entire category of cases that the War Boys line is about, where things are not mandatory, but which are open to the decision maker to take into account if appropriate. If as soon as you find it's not mandatory, you say, well, it's probably never relevant, then that whole line would fall apart. So what is the decision process for? And HMRC have said it tempers the rigour of this strict system. And in their case, at page 109, the third point they make in 59, they talk about providing clemency in appropriate cases. But if Parliament was thinking about, if Parliament wasn't thinking about the risk of being overly harsh, why is it appropriate to talk in terms of tempering the rigour of the system or offering clemency? We say, of course Parliament thought clemency might be appropriate in some cases. They knew this was a severe regime. They knew that the impact of losing your status might be severe, and that's why the discretion is there. As I think the revenue accept, it's a protection of the taxpayer that it's not obligatory. But if Parliament decided you had an interest worth protecting, and protecting both by a discretion and by a right of appeal, it seems surprising to say that you can't weigh the value of that interest to you when you're going through that protective process. HMRC have given some examples now where they say they think it would be appropriate not to revoke, but I'd say these don't actually fit the way the legislation works. First, the example they gave is where you dip below the required turnover. What's strange about that is that the Act gives the revenue power by regulation to allow you to keep gross payment status if you dip behind the required turnover. It gives that power in Schedule 11, paragraph 11, 4b. And
11.4b.
11.4b, it's page 287.
Yeah.
And they have not, in fact, used that power. That's not one of the circumstances they have allowed you to keep gross payment status even though you don't meet the turnover requirements. So it seems strange to give them the power to provide that by regulation, but say, well, if they decide not to, they can decide it on an ad hoc basis. It's now clear that...
What are you saying, that if you do, in the circumstance that he outlined, where someone does tip below turnover for a short period, but is likely to get back, is there nothing they can do?
Well, I say they have discretion.
You say they have a broad discretion.
Well, I'm saying that one of the reasons they have that discretion is so they can temper the rigour, which means noticing that this is excessively harsh on him for this minor temporary problem. But if that isn't something they're allowed to think about, if the damage to this person doesn't matter at all, then why is it appropriate to let them off? Why are you even talking in terms of letting them off? When Parliament gave the revenue power to define a public list of when you would qualify, and it just didn't put this in that list. In fact, didn't use that bit of its powers at all for these circumstances. Because a major part of that list is going to be it provided equal treatment, it provided clarity. They've adopted what's said in the upper tribunal about examples of where it would be appropriate, such as the late filing of accounts at Companies House, which isn't in Regulation 32. But
Sorry, make that point again.
the example that the upper tribunal gives,
Yeah.
Mr. Eady accepted, which is at 64 in the upper tribunal's decision. It's repeated again in the Court of Appeal. And that's the late filing of accounts at Companies House. This is something which is not in Regulation 32. But it said there's two problems with that if the harshness is something you simply put out of your mind. One is, say I've done this, I've filed my accounts very slightly late, and I ask for relief and the revenue refuse it. How am I supposed to challenge that? I've got a right of appeal, but I fall outside the public list of approved tolerable failures. I fall outside the reasonable excuse. I don't know that the revenue's policy is to allow this kind of thing through. I can't point to anything for the tribunal that says this is in some way unfair, because the tribunal has to forget about the fact that it matters to me that I've got this status. So I can't say it's trivial, I can't say it's excusable, and I can't say it's too harsh. But if the revenue do think it's okay to let you through if you're slightly late in filing your accounts, then shouldn't everybody who files their accounts slightly late be allowed through on the same basis, which is what Regulation 32 would do if they put it in there? Because there doesn't seem to be a material distinction between cases once you take the personal impact out of account. Because if I can't point to my own interest in keeping this status, it does seem a bit strange that I have a right of appeal at all. Because why, if Parliament wants this administered on the assumption that my own interest in these rights is to be forgotten about, why am I wasting the tribunal's time? There's a point that Mr. Eady made, I think, as a version of the this is needed to allow the revenue some flexibility. And I've said already that because they only do this when it appears to them, they're not required to keep a permanent watch. And he said, well, competitors might make a fuss if there wasn't a discretion. And I would say that there really is no risk of this since the decision of the House of Lords in the Federation of Small Businesses case. Particularly if you go to the manuscript 370 at B to D, where Lord Wilberforce explains that essentially it's impossible for one taxpayer to challenge the revenue about how another taxpayer is being treated.
Sorry, there's three.
Page 370 at B to D.
Well, the bit you quote in your case is Lord Scarman, who said the opposite.
Well, I wouldn't say he's saying the opposite. Lord Scarman is saying that...
I think he was in a minority, but there we are.
Well, there's this point which he seems to be quoted about regularly since, that there's a general obligation on the revenue to treat people fairly, which, however, it's pretty much impossible for any individual to complain about because they're not allowed to know what's happened to other people. But I think it does seem to be quoted regularly enough, Scarman's observation that, yes, the revenue are under public duty not to...
Yes,
it may have very difficult to find out.
It was quoted out of context
Yes.
with regard to the fact that he was in a minority.
But he did agree with the result.
Anyway, never mind.
Yes.
I mean, your point is that they needn't worry because they can't be challenged by a rival competitor if they've exercised discretion in the wrong way.
Yes, I'm saying that this is...
What is actually, what I haven't picked up, what is the jurisdiction of the first tier tribunal? Can it substitute its own decision?
I think the position has been taken that it can't.
Can't.
That it partly because it's described as a power to review their decision.
Yes.
And which is why in this case they simply allowed the appeal, meaning that the revenue would be required.
Yes, they said that the revenue had erred in failing to take into account a relevant matter.
Yes.
But if you're right that there's a general unfairness review, or at least power in the revenue, all the first tier tribunal could do is to say either you've exercised it irrationally or not, or failed to take into account.
Yes, that's what the first tier tribunal thought, and my submission is that they were right, which is why they didn't remake it. They quashed it and said, well, the revenue must take a new decision on the facts as are presently the case. Now, HMRC's view as to what they are supposed to do when they exercise their discretion, I would say does amount to the old relief for minor and technical failures. And the main reason I say this is objectionable is that that old relief existed prior to the discretion. So until 2004, you had to be satisfied that the failures were not minor and technical, giving rise to no fear of future compliance. But if you decided that they didn't fall within that, they were more than minor and technical, you then had the choice, as you do now. So it's a little bit surprising if you were then having the choice to essentially make the same judgment call twice. But moreover, well...
Sorry, under the new regime, we wouldn't be making the same judgment.
No, new regime, you wouldn't be making it
But
twice.
what you're saying is that it would suggest the revenues argument that you would have been under the old regime.
Yes, my lord.
Yeah.
And under the new regime, Mr. Eady said, well, when they abolished that and replaced it by the fixed rule, surely they weren't intending to remove all flexibility on this kind of question. But, I mean, that does look like what they were trying to do. They removed the minor and technical weighing exercise. There's a suggestion. There's been the suggestion that I should probably take you, just, or at least refer you. There's more discussion of what the minor and technical exercise looked like in, I think, particularly Templeton, Manuscript 692 at 14. And it's just that the way it's described does sound an awful lot like what the revenue say they now do at the discretion stage. In terms of the terrible consequences for the revenue of doing all of this, of being forced to carry through this exercise, I would say first, we pointed to the points where they're able to ameliorate penalties, and we said, well, that's less of an incommensurate balancing exercise. But in Lindsay, the question was, do you restore a vehicle or not? They were maintaining a policy that said they basically wouldn't, and they were told, no, you've got to bring in considerations of impact, balancing that against equally incommensurable public goods about deterring smuggling and so on. And I've put in my case the reference to the passage in Denley, which is just they set out how they go about dealing with this question when they're asked to restore. They ask, well, is this exceptional enough to go outside? Have you made a case that this is exceptional and goes outside our general policy? If you hadn't, we just apply our policy. This is something that the revenue are perfectly capable of doing. And finally, there was discussion of whether this might be an impact, though impact on its own might not be relevant, impact that had a knock-on effect on the tax revenues might be. And I would say if that's the case, the only way you could really assess that would be cases where the impact is such as to severely diminish the profitability of the business, which is our case on the facts as found. Because I do say that there are going to be different degrees of hardship in different cases. This is not a case where you're treated, you'd have to assume that the same amount of damage is done to any subcontractor by removing gross payment status. The facts found here shows that the tribunal, the revenue, are perfectly capable of looking at the individual case and saying, well, you are going to lose 3/4 of your business. Or, no, actually, we think you aren't. Consequence of that is some people get to keep the status who otherwise wouldn't. That's the consequence of there being a discretion. Some people get to keep the status who otherwise wouldn't. And I think Ms. Boyd will reply on the issues of human rights.
Yes, thank you very much. Yes, Ms. Boyd.
My Lords, just briefly on the question of what possession, A1P1 possessions, we're dealing with here, and why A1P1 is engaged. Mr. Eadie emphasises the conditionality of the right to receive the gross sum in light of the provisions of the CIS. And it's important that I clarify what possessions we are relying on, because there are in fact three separate possessions. We say that the conditionality argument fails in relation to each of them, but for different reasons. So the three possessions, first of all, we rely on the chosen action constituted by your right under the contract. Mr. Eadie says a chosen action, a contractual right, can in principle be an A1P1 possession. Secondly, the possession constituted by the sum, the gross sum that is due under the contract for your services. And what we are talking about there is plainly not a right under national law to the gross sum. There isn't a right under national law either to retain or even to receive the gross sum given the CIS. Nonetheless, there's an A1P1 possession constituted by the gross sum, we say, simply because it is the gross sum that represents your earnings under the contract. So it's the sum that is in principle payable to you for the work you have done. And indeed, unless that constituted a possession of yours for these purposes, you couldn't be taxed on the gross sum. And that's the reasoning of the European Court in the Hungary case, which I took you this morning. And a further point to clarify in that regard, we're not asserting a right to 3 months of cash flow, and the interference that we complain of, or that we say gets us in through the A1P1 portal, is not a deprivation by means of legislation that provides for tax deduction at source. It is a control of use. Taxation legislation deprives us of some of the possession constituted by the gross amount that we are due. But legislation that simply provides for deduction of taxation at source doesn't deprive us of something we would otherwise be able to retain. What it does is prevent us from being able to receive it and therefore have use of it for that time. And we're not saying there's a right to the use of the money that is thereby, of which we are thereby deprived. We're saying that we have an interest, a possessory interest in the entire sum, which is interfered with by legislation that prevents us from receiving it all and then accounting for it. And then the third separate possession we rely on is the status of GPR itself, which is maybe a bit like a license. It's not actually a license, but it's a status with real economic value and consequences for the health of the business. Now, we say that in case of none of those possessions does Mr. Eadie's argument on conditionality prevent the application of A1P1. So, first of all, he says, and this is in his written case, that there's no right in a subcontractor to be paid the whole of the contracted price. This is dealing with the first possession, the contractual right, because the contractual right has always been subject to the CIS. It's, of course, right that the contractual right to receive payment is subject to the CIS, in the sense that given the provisions of the CIS, a contractor is entitled to pay the subcontractor the gross sum that is due if and only if the subcontractor is registered for gross payment. But that doesn't mean we say that for A1P1 purposes the subcontractor has no right under the contract to be paid the whole of the contracted price. And the correct analysis on our case is that unless he's registered for GPR, the legislation supervenes to prevent him from receiving his gross fee in accordance with the contractual entitlement. So in other words, the legislation interferes with, rather than delineating, the possession constituted by the contractual entitlement to pay. The point can be tested as follows. Suppose a contractor concludes a contract with a subcontractor who's not registered for GPR, which provides for a contract price of £100. Because of the CIS legislation, the subcontractor is not entitled to receive £100, but only the lesser amount. But suppose the legislation was suddenly repealed, then the subcontractor would be entitled under the contract to receive £100, and he'd be so entitled as a matter of contract, even though the repeal of the legislation would not entail any change in the contractual terms. So we say there's a right in the contract, which is an A1P1 possession. The legislation sits on top and interferes with your ability to enjoy that right. But that doesn't mean that there isn't such a right transcending the bounds of that legislation. In any event, the possession constituted by the gross sum you are due for your services under the contract is not conditional in any way on the status of gross payment registration. It simply, it transcends the legislation, it transcends the contractual entitlements. It's a possession you have in virtue of this being money due in respect of your work on which you are taxed. And the third possession, the status of GPR itself, well, we accept that the grant of GPR is conditional on satisfaction of the legislative conditions for grant. But that doesn't mean that maintenance or retention of that status is conditional on continuing to satisfy those conditions. It's not conditional in the relevant sense, for the reason I gave this morning, because cancellation is discretionary, not mandatory. It may be that if you cease to satisfy, well, it is the case that if you cease to satisfy the conditions, you're no longer entitled to gross payment registration. But that doesn't mean that you don't have it. You have it until and unless it's removed by the revenue. If they decide not to cancel it, you retain that possession. From which it follows, we say that cancellation is an interference with that possession. It's deprivation of that possession. It's, of course, an entirely separate question whether that might be proportionate and strike a fair balance and lawful and so on. But there's deprivation, and so we are in A1P1 territory. And a more general basic point about conditionality is that the fact that national law permits removal of a possession, and in that sense the possession is conditional, can't mean that there's no interference in itself. Otherwise there'd be no such thing as an interference with an A1P1 possession that was not in accordance with the law. And of course that's contrary to the wording of A1P1, which says that no one should be deprived of peaceful enjoyment of their possessions save in accordance with the law. That's the first requirement. Which presupposes that there can be such a thing as a deprivation of an A1P1 possession that is not in accordance with the law. That is in accordance with the law. And quickly, finally, on the subject of fair balance, I do accept that what we are saying is that a provision which confers a discretion but prohibits the individual decision maker from assessing proportionality is out with the margin of discretion. Parliament can't, compatibly with the Convention, legislate to the requirement of proportionality. It can legislate for a general measure, and in that way purport to prevent proportionality from being considered at the individual level. But in the cases in which that's being considered, the court has either held that an ability to assess proportionality needs to be read in, without being deterred by the margin of appreciation, or it has approved the general measure only after concluding that there are convincing justifications for generality and the legislative purpose would be imperilled by a less general arrangement. And for the reasons I gave this morning, we don't accept that that high test is satisfied in this case.
What's the best case which puts it that high?
My Lord, we'd say that's implicit in the way it was approached in animal defenders and in Lawrence and Fenn Tigers, and the latter made reference to how it had been approached in the European Court. Those are cases relied on by the defendant, but we say they in fact support our case. So those are my submissions.
Thank you very much indeed. Well, the Court's grateful to counsel on both sides for their arguments, and will take time to consider its judgment. Court's adjourned.